Good afternoon. My apologies for not being with you in Melbourne today. I would like to start with a brief snapshot of people with disability in Australia. It demonstrates how far we have to go to ensure human rights and equality for people with disability. Data shows that 1 in 5 Australians have a disability, with this number increasing. The prevalence of disability in Aboriginal and Torres Strait Islander communities is 2 to 3 times higher than for the rest of the population. 45% of people with disability in Australia live in or near poverty, more than double the OECD average of 22%. The current employment rate of people with disability in Australia is low against the OECD average. People with disability in Australia are only half as likely to be employed as people without a disability. The situation is worse for women with disability. Given the low unemployment rate, it is unsurprising that many people with disability are dependent on income support, such as the disability support pension, and increasing on the below the poverty line New Start allowance. Government policy is increasingly shifting people with disability from the DSP to New Start, further entrenching poverty. Although there is little data, it is estimated that the incidence of violence against people with disability is at least 3 times higher than in the general population, with much higher rates for women with disabilities, particularly Aboriginal and Torres Strait Islander women with disability. This violence is less likely to be reported, investigated, or prosecuted. The little evidence available demonstrates that people with disability have a reduced life expectancy, 54 years with people with disability living in institutional care, and 46 years for people with intellectual disability. It is now well known that people with disability, particularly people with cognitive impairment and psychosocial disability, are overrepresented in the criminal justice system. Recent research in New South Wales shows that people with disability are 3 to 9 times more likely to be part of the prison population. People with disability are often isolated and segregated, living in institutional settings where they can receive inappropriate care. This makes them extremely vulnerable to violence, abuse, and neglect. Disability has traditionally been understood as individual deficit, as an individual problem to be solved or cured. This understanding perceives people with disability as objects or passive recipients of welfare and care. It has led to legal, policy and program responses that are focused on care, treatment and protection of people with disability. Essential to these responses has been a focus on special laws, policies and programs that segregate people with disability from the life of the community, such as special education. Traditionally, if people with disability were educated at all, they would need to attend special schools. The legacy of this today can be seen in special units or segregated school activities within mainstream schools. Sheltered workshops, now known as Australian Disability Enterprises. The low educational expectations and outcomes for people with disability still reinforces the perceived need for segregated employment options, despite a more contemporary focus on open employment outcomes. Segregated and concrete living, residential care and supported accommodation settings, where traditionally people with disability were placed from birth or early childhood into large residential institutions. There is a perception that these institutions have closed, but in fact, institutional environments still exist today and are still being built. Even smaller group homes and specialist facilities that are common forms of supported accommodation today are institutional in their design and operation. It is still common even in the new disability insurance scheme environment, for policy discussions to focus on specialist disability accommodation rather than housing when it involves people with disability. Guardianship. Traditional guardianship models have been of a plenary nature that strips people with disability of their legal personality, effectively a civil death. You don't exist as a legal entity. Australian jurisdictions don't apply plenary guardianship, but make limited declarations of decision-making capacity in certain areas, generally medical decisions and financial management. While not plenary in nature, this guardianship is still based on an assumption that people with disability, most commonly people with cognitive impairment or psychosocial disability, cannot make decisions in these areas and require another person to do so. It ignores the fact that everyone needs support in making decisions and everyone makes irrational and risky decisions. The substitute standard removes the person with disability from the decisions about their lives, and the substitute decision maker generally applies a standard of best interests. Decisions do not have to reflect an individual's will or preference and may be contrary to their will or preference. This deficit model of disability has left people with disability segregated, socially isolated, vulnerable to violence, abuse, and with substantial economic and social disadvantage, as is the basis for significant human rights violations. An alternative view of disability is one of diversity, where disability is conceptualised as one aspect of the human condition. Traditionally, social structures have been based on a social norm of the valued citizen, who is male, cognitively, socially, and emotionally able and competent, biologically and psychologically stable, genetically and hormonally sound, and ontologically responsible, hearing, mobile, seeing, walking, and normal, sane, autonomous, self-sufficient, self-governing, reasonable, law-abiding, and economically viable. This norm is a form of ableism, and it generally is internalised, often unstated, and can appear natural, neutral, and benign. Ableism, like sexism and racism, is underpinned by power dynamics. It ignores the full diversity of the human condition. Social structures create barriers for participation for people with impairment, which has a disabling impact on their lives. Understanding this dynamic relationship between impairment and disability is central to an ableist analysis. In responding to ableism, the disability rights movement has long argued for disability to be understood as a human rights issue and for laws, policy, and programs to be framed within a human rights approach. A human rights approach recognises people with disability as rights bearers, not passive recipients of care, protection, and a human rights approach provides a framework for the removal of barriers, including discrimination. This framework is articulated through the Convention on the Rights of Persons with Disabilities, which places obligations on states parties or nations that have ratified the CRPD to respect, protect and fulfil the human rights and fundamental freedoms of all people with disabilities. 2019 marks the beginning of the second decade of the entry into force of the Convention on the Rights of Persons with Disabilities. The CRPD was the first human rights treaty of the 21st century, setting out a contemporary agenda of human rights and fundamental freedoms in the specific context of disability. The fundamental premise of CRPD is that disability is just one aspect of the human condition. It acknowledges that people are not defined by just one personal characteristic and that we all experience discrimination in a multiplicity of ways. A fundamental tenet of the CRPD is universalism, that the modification of the social norm to reflect human diversity is the way forward. The CRPD is a normative frame that sets standards for society where politics, policy and law need to be fashioned around a complete, comprehensive vision of the human experience. It's only through such a vision that we are to meet the needs of real-life subjects and address human rights violations experienced by all persons with disabilities. The CRPD approach is a significant shift away from the prevailing social conceptualisation of disability that reflects a deficit approach, where disability is viewed as a problem, an individual issue, where vulnerable individuals require care, treatment and protection within a social welfare regime, thereby othering them due to their difference. The CRPD provides a framework for transformative equality. It doesn't define disability, it conceptualises it as a dynamic relationship between people with impairments and the environment and social institutions. It recognises disability as an evolving concept. Disability is not static, it can be evolving now and in the future. So our understanding of disability may be very different in 50 years' time. For example, technological changes and advances are already providing people with disability with alternative forms of communication and greater independent living situations, changing their relationship with their environment. We now accept that eye health is integrated into our health system, making it easier to have eye checks and obtain corrective glasses. If this wasn't the case, such as may be the situation in many developing countries, then the relationship between the person with vision impairment and the environment becomes disabling and they cannot participate in community life. The CRPD provides a blueprint for the removal of barriers to inclusion. It outlines positive measures to accommodate difference and initiate structural change. This is not just a blueprint for the removal of barriers in the physical environment, but also the removal of social dynamics that are barriers to inclusion. It's about legal policy and practice transformation. The aim is to respect and include difference within society by removing the disadvantage, the discrimination, the detriment, but not the difference itself. It's about embracing difference as integral to the human condition. Australia ratified CRPD in 2008 and is legally bound by the obligations it signed up to with the community of nations. The challenge for Australia is to identify and reform current laws, policies and programs that create barriers to inclusion for people with disability. Reform of the overarching legal and policy framework that addresses disability is critical to this. The Disability Discrimination Act is anti-discrimination legislation that addresses one aspect of the CRPD, set out in terms of non-discrimination. It predates the CRPD and it has played a critical role in social change for people with disability, but it is very limited. It's an individual complaint mechanism that places the onus on individuals to claim their rights. It operates within a cost jurisdiction, so if conciliation fails, the individual has to take the matter to court, where they potentially face adverse cost orders if they fail. The grounds for discrimination are limited to certain fields of public life, such as employment, education, the provision of goods and services. These are important areas, but the DDA can't address, for example, violence against people with disability or the placement of people with disability in segregated institutional settings. The National Disability Strategy was launched in 2010 after extensive consultation with people with disability. During the process, individuals' experiences were recorded, which led to the Shutout Report, which documented people's personal stories of daily existence in an inaccessible society and disability service system that was unfair, underfunded, inequitable, and standardised rather than individualised. As a result of the report, the conversation changed to include a twin-track approach that was both vertical with the National Disability Insurance Scheme and horizontal with the National Disability Strategy. Because the NDIS is an insurance scheme, it is necessary to demonstrate deficits in order to enter the scheme. The symbiotic relationship between the NDS and the NDIS should have balanced out the deficit focus, however. The lack of progress on the NDS has meant that the deficit focus has gained greater traction than was intended. The individualised approach of the NDIS is something of a two-edged sword. The necessary focus on the individual can mean that the systemic universal changes that make a society inclusive get overlooked. This disadvantages everyone because the knowledge and understanding needed for an inclusive society that conceptualises disability as part of human diversity is not demonstrated or taught. The traditional view of disability that has underpinned Australia's approach in recent history, for example, is demonstrated by the fact that the NDIS was to be called disability care. The NDS and the NDIS represent Australia's response to the CRPD. However, the lack of funding for the NDS has skewed our approach, leaving us behind our inclusive goals. This is further exacerbated by the removal of service provision responsibilities from the states, who are now under no obligation to implement the NDS. The Productivity Commission identified the need for a new national disability agreement between the federal and state governments that would clearly set out the responsibilities of governments to provide disability services outside the NDIS and to affirm the commitment of the governments to address service gaps and barriers that people with disability face in accessing mainstream services. Nonetheless, the success of such an agreement will depend heavily on prioritising funding. In this respect, the visibility of the NDIS and the lack of knowledge of disability in the community contributes to a misleading impression of a well-funded sector that could undermine community willingness to invest more. A number of Australian laws, policies and practices deny or diminish recognition of people with disability as persons before the law, or deny or diminish the right of a person with disability to exercise legal capacity. Guardianship, estate management and mental health laws regulate the area of legal capacity, financial management and substitute decision-making in Australia. These laws differ between states and territories, resulting in inconsistency and primarily focus on a person's capability to perform particular actions, as opposed to looking at how a person can be supported to perform those tasks themselves. Whilst Australia does not have a plenary guardianship system, these laws are not consistent with or fail to fulfil obligations under the Convention. A number of jurisdictions are piloting supported decision-making. 4 state and territory governments, New South Wales, South Australia, Victoria and the Australian Capital Territory, have piloted supported decision-making initiatives, which are important steps towards reform of substitute decision-making. However, these initiatives are confined to specific jurisdictions and are being conducted within the existing guardianship framework rather than being part of a comprehensive review of substitute decision-making itself. In November 2014, the Australian Law Reform Commission tabled in Parliament the final report of its inquiry into barriers to equal recognition before the law and legal capacity for people with disability. The inquiry considered Commonwealth laws and legal frameworks that deny or diminish the equal recognition of people with disability as persons before the law and their ability to exercise legal capacity, and what, if any, changes could be made. The Commission's final report, Equality, Capacity and Disability in Commonwealth Laws, makes 55 recommendations for reform aimed at providing people with disability equal recognition before the law, in particular in relation to the right to make decisions that affect their lives and to have those decisions respected. However, the government is yet to respond to the report. All Australian jurisdictions have in place legislation that addresses a defendant within the criminal justice system and their fitness to stand trial. These justice diversion provisions are applied when people with cognitive or psychosocial disability are deemed unfit to stand trial. An unfitness test may arise as an issue before or during the trial process. These justice diversion provisions have resulted in people with disability being detained indefinitely in prisons or psychiatric facilities without being convicted of a crime, and for periods that may significantly exceed the maximum period of custodial sentence for the offence. This situation is exacerbated by a lack of appropriate accommodation, therapeutic and disability support options available for people with disability who are deemed unfit to stand trial due to an intellectual or cognitive or psychosocial disability. This practice of arbitrary detention is disproportionately experienced by Aboriginal and Torres Strait Islander people with disability. In November 2015, the Australian Government made a welcome voluntary commitment to the United Nations Human Rights Council during the Universal Periodic Review of Australia. The UPR is the process for reviewing the human rights records of member states by member states of the Human Rights Council. Australia committed to improving the way the criminal justice system treats people with cognitive disability who are unfit to plead or found not guilty by reason of mental impairment, and that it would initiate a national effort to analyse existing data and develop best practice resources for Australian jurisdictions. However, it is unclear as to what action is occurring to implement this commitment. In May 2016, the Senate Standing Committee on Community Affairs began its inquiry into the indefinite detention of people with cognitive and psychiatric impairment in Australia. There has been little response to the recommendations from this report. Importantly, in August 2016, the UN Committee on the Rights of Persons with Disabilities handed down a significant decision in relation to an individual communication made by Marlon Noble. Mr. Noble is an Aboriginal man with a cognitive impairment who was found unfit to plead and held in a WA prison for 10 years without conviction. Although eventually released, he remains under strict conditions that limit his ability to access the community. The UN found that Australia had failed to fulfil its obligations to Mr. Noble under the CRPD, including in relation to recognition of Mr. Noble's legal capacity and access to justice, and his right to liberty and security, and his right to be free from torture, cruel, inhuman or degrading treatment or punishment. The UN recommended that Australia remedy this situation by revoking Mr Noble's release order, providing him with support measures for his inclusion in the community, and by amending WA law and all related federal and state and territory legislation by providing adequate support and accommodation to enable people with disability to exercise their legal capacity, to provide regular training on the exercise of legal capacity to review boards, members of parliament and judicial officers. From this brief analysis of the overarching legal and policy framework, it is clear that law and policy is still largely based on an individual deficit model of disability. There needs to be significant legal, policy and program reform to address this still. Thank you.